Good morning, everyone, and welcome. My name is Tiffany Johannes, and I am your 2023 Canopy Realtor Association, Canopy MLS, and Canopy Housing Foundation president. As a realtor, forms are one of our biggest tools of our trade. We depend on them to stay in compliance with rules and laws and help all parties to the transaction have a clearer understanding of the process. As you know, each year, the North Carolina Realtors Forum Committee makes changes to our forms. Some of these changes are small and others have a lot larger of an impact. That is why we are grateful to have a panel of experts who are our peers and NC Realtor attorney to talk about what the Forms Committee did and to discuss the changes and how to use the forms correctly to ensure an easier road to the closing table. As we get started, I just want to share a couple of upcoming events so that you're aware of them. And if you'd like to attend, we'd love to see you there. If you'd like to learn more about local down payment assistance programs and how to get more buyers into homes, register for the Creative Lending Financing Dreams course on Wednesday, July 19th. That's going to be via Zoom. This course is presented by the North Carolina Housing Foundation and is part of the Workforce Housing Certificate Program. And it offers 4 hours of CE elective credit. There are a few spaces still available, so register at canopyreinstitute.com. The summer is also a great time to experience a new Canopy campus. If you haven't checked it out yet, you should. The new continuing education year started July 1st, so stay ahead of the curve and schedule your 2023-2024 broker in charge update or general update early with our Canopy Real Estate Institute. The Canopy campus is the one-stop location for education and professional development. So definitely take a look at that. Then join us back here on Zoom on Monday, August 14th for an exciting program about the new Charlotte River District. It's a 1,400-acre master plan community built to connect city life with nature. You can register at www.canopyrealtors.com. At this time, I'd also like to thank our sponsor and have one for today, and it is TR Lawing. We're going to share a quick video with you, so thank you for your time, and we look forward to starting the program.
The road from licensure to earning money can be a long one, but we can put money in your pockets tomorrow. TR Lawing Realty pays a rental referral fee whenever you send us a tenant who rents one of our vacancies anywhere in our 12-county region. For more than 60 years, TR Lawing Realty has been the Charlotte region's premier full-service residential property manager. By managing the details, we help individuals invest in real estate. And we provide free advice to fellow realtors. That's right, no matter which firm you are with, we can work together. You make the sale and we will provide the long-term management services and even pay you a referral fee for the new account. All of our vacancies are on Canopy MLS and have Supra lock boxes. So remember TR Lawing Realty for property management services.
Thank you so much, TR Lawing, for being our sponsor today. And now I get the pleasure of introducing our panel. They are people that you know well and are your colleagues. First off, we have Jennifer Frontera with the NC Realtors Forums Committee. She is a 2023-2024 chair, and she is a past president of Canopy. Amy Baker is NC Realtors Forum Committee 2023-2024 vice chair. Melanie Coyne, she is NC Realtors Forum Committee for 2023 and 2024. And then John Waite, NC Realtors Legal Counsel, and he's also with Martin and Gifford PLLC. I know you're going to have a lot of questions, and we are going to try to address as many as we can. Our panel does have a PowerPoint presentation to review some of the highlights of the changes, and we will be dropping a summary into the chat as well. If you have any questions, you can type it in the Q&A box, and following the presentation, we will address as many as we have time for. Also note, this presentation is being recorded, and you will be able to find it at www.canopyrealtors.com by next week. Okay, let's get started. Welcome, panel. Thank you for being here.
Happy to be here.
John, do you want to get started with an introduction to the NC Realtors website?
Will do. Hello, everybody. One of the things whenever I do these forms change presentations is show you all where to go in case you have questions after the presentation. So I'm going to do that first, and then at some point in the program, or either in the chat or afterward, we'll give you the information for the NC Realtors legal hotline. The legal hotline is a free member service. If you have questions about forms, you can always call, talk to a lawyer same day. You can also email. So there's information for that we'll be getting to you. As far as navigating, I'm going to share my screen here. And a couple of weeks ago, if you haven't looked at it already, NC Realtors rolled out a new website. And I don't know how you guys feel about it, but basically from the first day the old website rolled out, I was waiting for the new website to roll out. I did not like the old website. It was difficult to navigate. The search bar didn't work very well. And so there was a lot of things that staff put in to make sure that this website works much better. And it does. So today, I'm showing you my screen here, but the interesting thing is this is a dynamic website, which means that on your phone, it's going to be a little bit different than, say, a smaller screen computer compared to a larger screen computer. So it's not always going to show up the same way. I'm going to show you just how to navigate here, but there's all sorts of things. One thing that I will point out, there's a risk management library. There's a whole bunch of articles that are not legal Q&As. They're actually completely separate articles, and they are meant to do exactly what it sounds like, provide risk management solutions. So up here, this is where the navigation is on my screen. It'll be a little bit different on yours. We're going to go to legal. And what we're going to do is go to the Q&As, okay? Let's see. There we go. Right here is a bar for the legal Q&As when you go to the legal part. And as you scroll down here, there's a couple different ways you can do it. This new website, the way it works is as you scroll down, it's going to go in order of their post. You can see a date over here, but you can also sort it up here by different methods. You can also use a search bar up here, and on different computers, it'll actually come up a little bit differently. But what I want to bring up here is right here, what we've released is a summary of all the forms changes. Today, we're just going to be hitting the highlights in this presentation. So if you click on this, it's going to come up with a web page. And what it has is here, number one is a summary. So these summaries go all the way through each form. And then each form has a hyperlink. And when you click on that hyperlink, it's going to take you to a marked up version of the form. So yellow highlighting strikes, much like you're going to see today. So this is a really good way where, especially if you're a broker or in charge, you want to go through these changes with your people, then this is a really good way to do it. It's a good resource. I wanted to make sure you guys were able to navigate that. Of course, if you have any issues or questions about that, we can help you do that too. I'm going to stop sharing, and then I'm going to turn it over to Jennifer, who's going to start with our first actual forms change.
Jennifer, you're muted.
All right, okay. So the first form we're talking about is 2T, offer to purchase and contract. This is 1C, so there's been some language that's been struck through, that's taken out, and the new language, the property will or will not include a manufactured home. The property will or will not include, and this is new, an offsite and or separate septic lot, boat slip, garage, parking space, or storage unit. And then the notice new as well. Manufactured home or a septic lot, boat slip, garage, parking space, or storage unit is included. The buyer and seller are strongly encouraged to include further details in the additional provisions addendum, which we are going to discuss in a little bit down in the presentation. So this is pretty straightforward. And next we have.
So the next change is also on the first page. These are more cleanup changes. At the request of one of the attorneys on the Joint Forms Committee, we changed the word by to on the effective date for when the due diligence fee is due. So there's no substantive change to how we do our business. It's just a cleanup change there. The same with the change to the earnest money section, the initial earnest money. It's just a reformatting of that paragraph. The initial earnest money is due within 5 days of the effective date of the contract.
And then this next one, this is not a change as much as, just like Melanie said, a cleanup. So the language that was stricken actually appears other places in the offer to purchase. So paragraph 23 already dictates what would happen with the earnest money in various situations, such as buyer or seller breach. So we realized that this was really just a duplicate, and this paragraph could be simplified.
This is actually a change that it was at my recommendation, I think. And I'm not sure I'm not sure what to do with it, because it's already at the end of the contract as well. Basically, the reason this change came about is because it is one of the most common questions we get on the legal hotline at my law firm. And that is, if you pay the money, or if the money's not paid when the contract is signed, do you have a valid contract? The answer is unequivocally yes. The effective date, this paragraph here that's on here, says that it's going to become effective when the last one of the buyer or seller signed, and then the signing is communicated. You don't even have to deliver the actual signed contract to the side. A text message, a verbal phone call, anything. If your client is signed, your client's the last person to sign. You indicate to the other side that that's happened. You now have an effective contract. No payment of the money has anything to do with that whatsoever. Instead, earlier in Form 2T, above this paragraph, which we can't see it in context here, but there's a mechanism for the seller to demand the money if the money's not paid on time, and then they'll have the ability to terminate after one banking day if it's not paid after the demand is made. And actually, Form 355 is there to help you make that demand if you need to make it. In any event, this language is added here because this is really where it needs to go, but also just understand this also goes at the end of the contract. So if you or your clients or any of your agents have any questions about whether there is an effective contract based on whether the money's been paid or not, the answer is here, as well as the end of the contract.
So this next change, it's just a simple change in addition to the fixtures section in 2B. Since COVID, a lot of people have decided to have home gyms, and a lot of things have been attached. So if there is exercise equipment or devices that are attached, that's now been added. And the difference between those is, for example, an equipment might be a dance bar, a punching bag or kick bag, some kind of bars or a rack, rock climbing wall, whatever it might be. And then a device would be something like a tonal, where it is an actual device that's been anchored into a wall. And so on the next screen, we have the 2E. And so just this change from shall to must, it's just a better word. Seller must repair any damage caused by removal of any items in good and workmanlike manner, and seller will notify buyer upon completion of such repair and provide buyer with documentation thereof. So some of these things are anchored a lot more vigorously than a mirror. Their poles are bigger, and a tonal can be professionally anchored. And so if your seller wants to take their very expensive tonal with them, then that's a conversation you need to have with them and make sure it's repaired accordingly. And then the note, buyer is advised to consider attaching additional provisions at addendum, which we will discuss further.
Next change we'll cover is in the list of recommended activities for the buyer's property investigation. The Romanet 6 here is an existing section, but we have expanded it to go along with a change under the seller obligation section that John's going to be talking about shortly. The existing section suggests that the buyer investigate the property from a government regulation standpoint for their contemplated future uses. The change suggests that they also investigate it to make sure that in its current condition, it complies with any law, ordinance, regulation, statute that might affect the property. and potentially have some negative repercussions down the road if these things are not discovered. A number of these elements can only be discovered with a current and complete survey. So that survey is recommended elsewhere on this list, and this is just an opportunity to double down on that recommendation to the buyer that they have a current and complete survey.
So this one is also not a change, but a clarification and really just pointing something out. So the Residential Lead-Based Paint Hazard Reduction Act of 1992, so definitely not new, requires that the lead-based paint addendum or the disclosure be attached to the contract and given to a buyer. So we simply added a warning box to point that out because under that law, if that was not to be given, the buyer may have an out in the contract. So really, this is just to highlight to listing agents and sellers that that absolutely needs to happen so that that buyer does not have that right. And me again. This was previously just on the additional provisions addendum, but in some of our discussions, things that are on the additional provisions, sometimes they're not top of mind. So we moved this on to the offer to purchase and contract so that it was a checkbox. This also will help out closing attorneys so that they will know if they need to look for security deposits, rental agreements, things that maybe need to be transferred over to the buyer. We often get not only from you all, but from closing attorneys if they're having issues with the contract. And if my memory serves me correctly, I think this one was maybe sourced from a closing attorney that would prefer to have this more top of mind on the offer to purchase. So this was added here, but still also remains on the additional provisions addendum for more clarification about the lease.
All right, so I don't know how you guys feel, but it feels like we've been kind of zipping along so far, and I'm about to stop that entirely. We have hit a mud patch, and you're going to need to buckle up a little bit so we could talk about this new paragraph 8H. And I'll briefly touch on the things in 8G, but really 8H is the big one. And just so the panel is aware, I'll turn it over to you guys too after I'm done blathering, so that if you want to add something about this, you can. So starting with 8G, there is actually a change in here worth noting. A lot of this is language cleanup in 8G, but the addition of the word materially, which we're going to talk about a little bit more in 8H also, is an important addition here. Mostly because there were some transactions that were being held up because, say, there would be a tiny encroachment or something like that. And then one of the parties would try to leverage that encroachment to try and get out based on the old language. The addition of this word materially means, there better be a significant encroachment. Material, actually just wrote a Q&A that was released this past week on Monday that really goes into the definition of material. Maybe, sorry, it was last week. In any event, there's a Q&A I wrote on 8H. It talks about material, and really what it means is that it's got to be significant. It's got to be something that's going to actually be significant enough to affect someone's decision-making process. A tiny encroachment that really is, as far as the value of the property is nothing, as far as maybe fixing it, nothing, and as far as affecting the title is truly a nothing. Those sorts of things are not going to qualify to argue that the seller is somehow in breach of 8G. But moving on to 8H, there's been a lot of questions on this. I can tell you that the Forms Committee and the Joint Forms Task Force members, of which, on the Forms Committee, I guess I'll give just a brief little history, just because I think it's helpful to know that these things don't just materialize out of the clear blue. It's not like I wake up one morning and think, you know what, there needs to be a governmental compliance paragraph. And then I just shove it in there and I'm like, you all have to take it. Yeah. No. That's not how this works. The Forms Committee is like 20, 25 realtors, plus a lawyer from the Real Estate Commission. And I'm on there as a non-voting member. I try and help draft things, try and help, solve the problems. But, that's who's on that committee. Then Form 2T is a joint form, which means that it also has to go through the Joint Forms Task Force, which is a joint committee between some members of the Forms Committee and closing attorneys who are members of the real property section in the NC Bar Association. So these are not just, lawyers who are dragging their knuckles around the courthouse doing criminal cases and then deciding to go write, real property things. I mean, we are talking about guys who are experienced in the industry, okay? And girls, sorry. I didn't mean to be gender specific there. In any event, so you're talking at the end of the day about 40 people who discussed this particular paragraph and hammered on the language of it for hours and hours and hours, and further had extensive discussions about, is this a good idea or not? And at the end of the day, it was decided that yes, this is a good idea. And the reason is because of the problem that was brought to the committee to solve. And I will explain that problem. The problem previously, if you look at 8G, is that there is no real talk about governmental compliance. And so let's talk about a very common example, and probably going to be the most common example, I think, that comes up out of this paragraph. And that is issues with permitting or zoning, but I'm going to go with permitting. Those are probably the top two if I had to guess. But the buyer would go into contract, maybe give a big due diligence fee or something to that effect, get really committed into the contract. Then they get in there, they start doing their due diligence, and the seller has not disclosed that they finished the basement but didn't get any permits for finishing the basement. Well, this would put the buyer in a very difficult position, especially if it was found after the due diligence period, because the buyer can do due diligence inspections all the way till closing. I mean, there's nothing to stop them from doing inspections to closing. If you look at the contract, that's what they're allowed to do. So sometimes that's when these things would be discovered, and in which case the earnest money would be at risk as well as the due diligence fee already committed. So the buyer would discover this, and there would be potential tax issues is one issue that comes along with these sorts of things, because if there's finished space that wasn't in there before tax office has ever been informed, then there may be tax penalties that could be assessed to the buyer if they buy the property. Maybe they will, maybe they won't. Some counties are more aggressive on enforcing these sort of tax issues than others. Same thing that you'll see stormwaters mentioned in this paragraph. Same thing with that. Some cities, counties are aggressive with if you've created impervious surface on your property that wasn't there before, it hasn't been permitted, then they may come after you, and it's a tax consequence for your property being out of compliance. But back to my example, buyer discovers this, and now all their money is at risk. They're looking at tax issues. They're looking at permitting issues. There may be something where in some situations you'll actually have the county permitting department involved in wanting changes to be made before they can deem the house habitable. There's a lot of issues that can arise in this arena, and all of you, I'm guessing, who've been around the industry for any length of time have run into one of these transactions where there's a governmental compliance issue with the property, and the buyer is stuck with this decision under the old contract of whether to accept all these deformities and close, or terminate and then try and hire legal counsel and get all their money back. The issue with that was that if the buyer chose to terminate and get their money back with, say, the assistance of legal counsel, their standing to do so was not great. It really wasn't. I think maybe some buyers had more success than others, but you have to understand the seller only has a duty to disclose latent material defects that are not within the discovery of the buyer by reasonable diligence. Well, the buyer discovers these things by reasonable diligence. They're doing their due diligence. They discover, say, a permitting issue. So it's really hard to argue that the seller has somehow committed of some sort of foul that would require them to give all the money back to the buyer. So that was the issue that was coming up, and probably it was an issue that was always there, but was really pushed to the forefront because of the market conditions over the last couple of years, where you just have more buyers than there are sellers. And you further have, these pressures in the market, to put down more non-refundable money. And it just raises the stakes for people enough where they're going to get more litigious if things go wrong. So from that problem, we had a very extensive discussion about how to address that problem, which eventually created 8H. So let's talk about the actual paragraph. Okay. Number one, you have to understand it's got two safeguards before it's even going to kick in. If it does kick in, it's going to give the buyer a choice, which we'll get to in a minute. But understand that there's two things that got to be satisfied. And the first is in the first line of the paragraph. And that is, it has to be a material violation. There was extensive discussion in both committees. Let's say there's, somebody puts in a ceiling fan, they'll get a permit for that. And they live in a jurisdiction where there would be a permit required for that. Is that going to count? No, I don't think so. And nobody on the committee really thought so. And I'm not sure a judge would think so either. At least that's my best, guess. This hasn't been to court yet, so it hasn't been tested. However, the intent of adding that word material is that things like ceiling fans are small, issues that relate to building stormwater, impervious surface, environmental protection and zoning. If it's a small violation, insignificant, then it's not going to trigger this paragraph. So that's number one. So first, it's got to be a material violation. So what happens? Well, it's going to be a material violation that the seller hasn't disclosed. And that's the second safeguard. If the seller discloses something, even if they've only got a suspicion that the property may not be in compliance or something like that, if the seller makes a disclosure, then this paragraph is also not going to apply. And that comes right after. It's like the third bleeding into kind of the fourth line there, where it says that the property is being conveyed free of any material violations. So this is a representation by the seller, okay? That is being I'm giving you this property free of any material violations of governmental regulation, and that except for these things. And if the seller says what those things are, this paragraph is not going to apply as to those things. And so the buyer's not going to be able to use this paragraph to try and wiggle out of a contract that they don't want to be in, just because the seller disclosed it and they decided to go into contract anyway. Okay. So what happens if a violation is discovered after the effective date prior to closing? That's the next line there. So let's talk about what's going to happen if that occurs. Well, number one, going back to the first line, this paragraph is a condition of the contract. That means that this is going to operate by its own terms. Just because an issue of governmental compliance is found, that's not going to create a breach in 99% of cases. Okay, it's not, because this is a condition of the contract that must be satisfied, rather than just an obligation to the seller, where if the seller doesn't complete it, then they're going to be a breach, because the buyer's about to get an option here. Because if a violation is discovered after the effective date prior to closing that the seller is not disclosed, then the seller is going to have a choice. They can cure the violation, or if they don't, then the buyer can choose to accept and just close, or they can terminate and get their earnest money and due diligence fee back. Okay, not any costs having to do with the inspections or anything like that. They're just going to get the earnest money and due diligence fee. This is exactly the way the condition of property at closing paragraph works later in the contract, which is paragraph 11. You have to deliver the property in substantially the same or better condition at closing, and if you don't, then the same sort of it's also a condition, and the buyer has the same sort of remedies if the property is not in substantially the same or better condition. All that said, I'm going to turn it over to the panel here in just a second, since I don't know about you guys, but I get real tired of hearing my nasally Midwestern voice, although I've been in North Carolina over 20 years. So don't worry. I say I'm from here now, but it's grating. I understand. I appreciate your patience with this. But what I do want to say is that I think there's a full understanding that this isn't perfect. And I think every single person I've talked to is very open to feedback on this. There has been a lot of feedback. And I do think it's going to be a net benefit. Maybe it needs to be changed. Maybe it needs to be deleted. That's not up to me. But I do want you to know that there was a lot of thought that went into it before it was adopted, and that overall, it probably, hopefully, will be a net benefit. In any event, so I know that was a lot. I'll turn it over to my fellow panel members who are also on this committee and are actually voting members to give their thoughts if they like.
Well, I'll go ahead and jump in and just mention a little bit of the background to echo what John said about how this came to be identified as a need. We are a long state. The practice of real estate varies very much from the mountains to the Piedmont to the coast, and practices amongst closing attorneys vary even within one marketplace. One closing attorney might see a zoning violation as a title issue. Another one might say that has absolutely nothing to do with title. So it became apparent in our discussion about the changes to 8G that there were things that could materially affect a buyer's what they're purchasing that were not necessarily being addressed one way or the other in the contract. So this new section was an attempt to just identify the rules of engagement and give a buyer an option, and also make it clear that if the seller discloses something and the buyer moves forward with an offer and contract, knowing that disclosure, then they're taking responsibility for that knowledge. So I think that's a very powerful element of this section, and one that I personally was very glad to see.
I guess I would just add that, in our discussions, and a lot of this does come from the Joint Forms Committee, where there are closing attorneys that are seeing, nightmares at closing for these things that are popping up. One example given was maybe a house was flipped and there wasn't one permit pulled for a total house renovation. That really wasn't, discussed until later in the transaction. Or a garage addition was built that maybe affected multiple impervious surfaces, setbacks, no permits, and then it also had a tax implication. So this is meant for all of these, but a lot of it is meant for these extremes where buyers were finding out later in the transaction after putting down a lot of due diligence money. So think about those. But in real estate, we deal with everyday transactions, and there's lots of gray area. And I don't know that we would delete this, but we are open to looking at ways to tweak or make it better next year once this has had time to play out and see what all the implications are of it. But think about those extremes with your buyers and sellers when things inside that have been changed with plumbing, electrical rooms added, and nothing was permitted. So that can have a lot of implications for a buyer later on.
Anybody else? I don't want to rush past it, but I also want to keep us moving.
Nope, I'm all good on this one.
All right, sounds good. The final thing I will actually say about 8H is that if you were a listing agent who was representing a seller who didn't want to disclose one of these sort of governmental compliance issues before, which if you're a listing agent, it's more than likely, if it's material, it's going to be a material fact anyway that you got to disclose. And if you had a seller who decided to hide that from you, and this came up a bunch, maybe not for anybody in this room, but as far as questions I got on the hotline, this came up plenty. Seller doesn't tell their listing agent about something like this. Maybe they forgot, maybe they intentionally didn't disclose it, and then the buyer gets in this position where they're forced to fight for their money. Well, guess what? They're going to sue everybody, and they were suing everybody. And it wasn't like hypothetical. This was actually happening. So I just want to add that last part that this was something that we hoped would protect agents and buyer agents too, because there were other cases where buyers would look at their buyer agent being like, hey, you were supposed to look out for me on this thing. Why didn't you catch this? You should have known. This is your job. And they don't understand that. And frankly, lawyers, like litigation lawyers, don't understand that it probably isn't your job. You're not an inspector. Yes, you have certain skills, you have experience, but your job is to be the broker. And so what this does is hopefully alleviate some of those things with respect to risk exposure to liability and just claims, not even, they don't even have to be well-founded, just claims of potential liability. So hopefully this accomplishes that as well. And that was another part of our of the discussion that came up. Anyway, sorry, we can move on from that. We'll get out of that mud pit. We will, I'm sure, fall into another one shortly. This one you're just going to be angry at me about, I think. Whoever designated these slides, and just giving me all the ones that people are just going to scream at me afterwards. Okay, I have bad news. Don't fill out this blank anymore, period. I mean, it's very, very rare you are going to put down the name of who the deed is going to. So you need to get out of that habit. And I know changing habits is difficult, but you need to do that. Also, I'm going to note that we work very hard on these forms, but it's, you see 1 little I, 2 little I, 3 little I, 4 little I, and E. Sorry about that. We already fixed it, but just so you know, we're not perfect. We don't claim to be perfect. And yeah, I'm really disappointed that Amy and Melanie missed that one. That would have been, where were you guys on that one? Anyway. So this paragraph here has been changed. This was at the urging of the closing attorneys on joint forms. That's where it originated. But other people, definitely agreed that this is a consistent problem. I don't think anybody's blaming anybody. However, a lot of times when listing agent, buyer agents are putting, saying who the deed is to be made out to, you're simply getting it wrong. It's happening, according to some closing attorneys, more than half the time. And furthermore, there were certain situations coming up pretty regularly where the deed would need to be changed from whatever was in this paragraph. And then the seller would be like, no. And then it's like, well, do we have to amend the contract or not? This is truly a non-issue. It just has to do with the buyer who's actually named in the contract being able to get financing. It doesn't really change anything. It doesn't materially change the contract. We need an amendment. And so it was really causing a lot of issues, especially on the closing attorney side, and creating issues for agents and closing attorneys. So here's what we're going to do. Here's how this paragraph works, okay? You are not going to fill in the blank unless it's a special situation, which I will talk about in just a second, because just by automatic operation, you filling in nothing, the deed can be made out to the buyer, a corporation, LLC, or other business entity of which the buyer's sole owner or shareholder. So if you got somebody who goes into contract and they're like, hey, I want the deed to go to my LLC, you could just do it now. You don't need to do anything. It's already in there. Number 3, a trust or something like that for which the buyer's beneficiary, a relative, any relative of the buyer. So let's say, somebody's trying to buy a house, they're young, first-time home buyer, can't quite get the financing done. All right, let's bring mom in. All right, mom, you can come in. We don't need to make any changes. Nothing. We're good to go. Finally, we had the other. And what's the other for? Well, you're going to have situations where, let's say it's a boyfriend, a girlfriend, so a boyfriend, things of that nature. Anything that's not included in 1 through 4 goes into what is now 5. It should be 5 in your forms. That it should be. Lee assured me it's been fixed, so I feel confident it's been fixed. But that's the only time you're going to fill that out. So if one of the first 4 doesn't apply, then you're going to fill in the names. Okay. And so just, like I said, you're going to have to change the habit, and the blank is still there if you need it, but please try not to use it at the request of every closing attorney in the state. I think I could speak for all of them. That's all on that one.
And John, if you could just double down on what's in the parentheses before the blank, where it says insert name only. Don't insert as directed by attorney or some of the other language. Just that should never ever have happened, but it continued to, and this change was also an attempt to get away from that common insertion.
Yeah, to be determined was a common insertion. Yeah, put the names in there. If you're going to put something in there, put the names, but please make sure that it doesn't fit into one of the other categories.
Can I just add one thing before you? So we were very careful on how we worded in a corporation, limited liability company, or other business entity of which buyer is the sole owner or shareholder. So that if John Doe wants to buy a property and then John Doe's attorney advises him that he needs to put it in the name of his LLC, it is his LLC. So this is meant for that situation or trust, et cetera, and not for assigning it to another LLC that is completely separate from the buyer. It is for those situations, as John described, where a lender or an attorney is advising that a name needs to be added or the buyer needs to put it in a version of themselves.
All right. Finally. Okay, good. This is my last one for a little bit here. This is, and it's an easy one. Every once in a while, there was a situation where, and actually there was a real situation where the buyer went and had the contract notarized and then recorded it to gum up the seller's title so that they couldn't sell their property to someone else. This just makes it clear there'd be no recording of this agreement or any memorandum of the contract without the written consent of both parties. It wasn't really fair. It was kind of a dirty tactic, but not technically, not technically anything wrong with it necessarily. If it was happening, or if it did happen, it was putting the seller in kind of a bind to try and clear up their title. So we've added this in here to try and prevent those rare situations. And also, if you get a crazy client who really wants to do something like that, you can just point out to them this sentence here and be like, no, we're not doing that. That's a bad idea. All right.
Okay, so now we're at the additional provisions addendum. So this is for a property that there's a lease. This allows for direction and authorization to a property management company or an attorney who represents the seller to be allowed to release to buyer's agent, representative, closing attorney, or lender true and accurate copies of the above items, as well as a rent roll to include property address, amount of current monthly rent, security deposit, and all past due rent amounts. And so, above it talks about all the different things, deposits, uncured defaults, et cetera, all the things that would be involved with a lease and a rental. And then below, seller shall deliver assignment of any lease at or closing unless this lease is not permanent assignment. And then providing information to contact property manager or an attorney representing the seller, the owner of the property. That's easy enough. And then all this is important to make sure that something that the tenant doesn't have, extra keys, extra opening devices for something like a garage door or extra fobs, anything extra for that property that the seller is holding, they also have to hand those over. And we go through wording on these for a long time, and all means of access to the property. And we give some examples, but anything that would be opening a gate, a mailbox, door, pool fob, mailbox, mailroom, anything where they need access to something in that building and or property should be delivered to the buyer at closing.
So this one's also on the additional provisions addendum. This goes along with the new checkbox on the first page of the offer to purchase. This was another thing we really wrestled with this past year, season, whatever. We were finding that there were often things that go along with properties, like I own a condo and the condo association has a set number of garage units, and only some of the units own a garage. So some units may be sold with a garage, some may not. And it might not come up in a listing presentation. The thing I kept saying in our meetings was, it's a thing over there, right? So it's not something directly attached to the property. It's not something that might be, directly visible at a listing appointment. So this brings up that conversation with the seller. Is there something else that's not directly attached? Do you own one of those condo garage units? Is your septic system on another lot? Some higher end waterfront communities specifically, you own a lot and that's where your house is, but your septic system is actually over there, right? That same thing I kept doing. And then of course on Lake Norman, there are tons of options for docks. Do I own my dock? Does the HOA own my dock? Do I lease my dock? Do I own my dock? Is it deeded with the property? There are just a million different ways. So there wasn't a great way for us to provide really set options, which is why we left some open space. But really this paragraph was designed to start conversation. So this is mirrored in the listing agreement so that when you're meeting with a seller, you can have those conversations. Is there anything else? And then also, if that box is checked on the beginning of the offer to purchase, then you would come here and attach the additional provisions addendum. Because again, the offer to purchase, directs you to attach this. You go here and now I can specify, I own a condo on Lake Norman and I have a deeded interest in boat slip number 12, and that will convey with the property, right? You put that here. So hopefully that, like I said, starts conversation about these things. Since this is very new, this is another thing that we would be super open to feedback on how it works, if it needs edits, if there's something we missed. We hashed it out quite a bit, but we're certainly open to feedback on it.
The only thing I would add, and I forgot to mention on the first page, is this is also the checkbox on the first page, and this is a heads up to the closing attorney if there is something odd that they need to make sure that they have all the information on earlier than later in the closing process.
All right. So we're back to me. I'm going to add one more thing on boat slips. Boat slips are going to come up a little bit later today also. There was a common mistake or maybe a common abuse of the form that was happening prior to these changes. And that is that agents were using form 12T, which is the vacant land form, to just go ahead and buy and sell boat slips. We're giving you a whole toolbox to be able to deal with boat slips now. So there are times where that may be the solution. If it's actual real property that's under the boat slip, it's actually a physical real property interest. Yeah, sure. 12T has been had some small changes to it to assist in that and to be able to facilitate that. Otherwise, with all these other ancillary boat slip interests, you're going to have options on 2T, the additional provisions addendum, and also another new form that we're going to cover a little bit later. But all that said is, I just want to make sure that, if you are an agent who's, frequently using the vacant land contract to sell boat slips, please re-examine your process and get guidance on how you can better protect your client with, frankly, a more accurate, applicable contract. All right, we're on the seller possession after closing, form 2A8-T. A couple of changes to the first page of this. Number one, there was some parties who wanted to make some changes to the seller possession after closing agreement after they've already signed it. Make sure you consult with legal counsel to do that. That's the warning at the top. You have to understand this, and actually there's new guidelines this year for this form as well as the buyer possession form. And they're the first guidelines I've written. And what I really try to do in the guidelines is actually avoid, just restating parts of the form and really talk about issues that may come up just ancillary to the form. One of them being that this is a lease agreement. And what do you do if there's a situation where buyer or seller has to evict, the other? The guidelines go into that. I think they do a pretty good job of just giving you tools to be able to talk to your client if you get into those situations. In any event, so that's the first change right here on this page. The second one is that you now have some check boxes for the term of possession. And the first one is, a date certain, until 5 p.m. on blank date, or for a period of days after closing, which was the language that was there before. Next change for this form, this is really more of a cleanup that I'm just going to talk about a little bit in general instead of going through the language. The seller makes an acknowledgement that they're going to upkeep the property in its same condition. Okay, that's basically what this whole paragraph is supposed to do. However, with the way it was written before, it conflicted with the seller's indemnity paragraph on the next page. I'm not going to go into that. It's a technicality that I don't think really concerns you. All you need to know is that the language has been cleaned up and simplified a little bit to hopefully make it easier to explain to your seller client, hey, here's your obligation on how to maintain the property. And if the indemnity paragraph comes up later, then you can do that. But make sure that, you know, the seller excludes all the items, you know, in those lines. Those are important lines to fill out. If you're having a seller possession agreement, you don't want them to accidentally be responsible for upkeeping something they know is already on the verge of not working or something of that nature. And then finally, on this form, I think, maybe not, I shouldn't say finally unless I know it's finally. In any event, also in seller possession, there was actually a television interview over in Raleigh, and there's a situation where the buyer could not get the seller out. This language was cleaned up to make it more clear that, you know, you can't just pay this holdover fee in paragraph 4 and stay in the property as long as you're paying the holdover fee. So the language has been clarified to just make sure that you know, sellers can't get that idea. I don't think they could under the old version, but you know, just to make sure, we did that because you know, people never stop looking for ways to abuse language if they can. There's also been some cleanup with respect to trash and things like that, lawn maintenance. But the biggest one, this is actually, I think Amy brought this one up, the removal of the seller's property, really making it more clear that by the date of possession, this is paragraph 6 here at the bottom, that they remove all the garbage, debris of the property as well as personal property part of the purchase. It wasn't a big problem, but it was an occasional problem with this agreement where the seller was leaving things behind that they shouldn't be. That I thought that was a good change. And moving on to Form 101, this is the exclusive right to sell listing agreement. These 4 paragraphs here, we've already talked about it, I think mostly in some parts, so I'll just try and hit the highlights. The first one is in paragraph F, actually, we haven't really touched on yet. And that is that your seller needs to describe any known potential or pending dispute, violation, or litigation that involves the seller, the HOA, or the property. Mostly because, again, this is a situation where the seller wasn't telling the listing agent something that was a material fact the listing agent has to disclose, but the seller doesn't necessarily have that duty. This is to make sure you're keeping a client on the up and up and making sure you have the information that you need to make disclosures that are necessary. There's also a conversation listing agents should be having with sellers, especially if they're going to be subject to FIRPTA. This is to prompt that conversation. Paragraph G here, having the seller represent whether they are or not a foreign person. This is something where I know some of you are going to have concerns about this because you feel like maybe there could be, I don't know, discrimination or something like that by asking this question. You're not asking this question because you're trying to sort out who you may or may not give services to because of their background. That's not my experience with realtors anyway. It's just not. And actually, you know, it's interesting with the adoption of 10-5. My law firm actually represents some local boards as well as the state association. And, you know, you guys are holding each other accountable on this thing. So it's not, to me, that was not a concern, but I understand people who might be concerned about that want to be sensitive to it. This is simply because it's a tax issue. I mean, you really need to know about this because if you don't have the discussion with a client and then they happen to be a foreign person, then it could really throw a monkey wrench into your closing. So just make sure you're covering this with your client, find out that status so that you can make sure the transaction goes smoothly for them. And then, you know, this is the last 2 here. Give the seller the opportunity to make disclosures that they need to make so that you guys can fill out appropriately the new contract with respect to offsite septic lots, boat slips, garage, parking spaces, permits, and governmental compliance. The seller making disclosures on those sorts of things so that you can protect them in those issues, especially when the contract comes up.
there you go, sorry. Shifting over to the buyer agency agreement. The main change that we made with this one is one that I have gotten tremendously positive feedback on from BICs, from people who check paperwork. Previously on the buyer agency agreement, there were, shift down here, multiple dates on the first page. There was a date when the agreement was entered into, and then there was a date when the start of the term was going to go into effect. And it's too many dates. And people were often entering them incorrectly. So we've cleaned this up to align the buyer agency agreement now with the way we deal with all of our other agreements. The agreement is effective as of the effective date of the agreement contract, and we have now defined the effective date as the date when the communication of the last person signing is made. So it takes out the anomaly, it makes it just like all of our other forms, and we no longer have the two dates on the first page that were unnecessary and potentially confusing. So this is a very exciting change. Really shouldn't affect the way that we do business. It's just the way that we fill out this form, and it makes it much cleaner. Okay. Amy, you're up.
I'm back. Just flipping through some of you guys' questions too, trying to knock down that list. This is another new big one. So we have been requested to do a bill of sale for years. Some of the others on this committee have been on the committee longer than I have. I think I'm on 4 or 5 years, something like that. And I've even seen it multiple times. So we've always wrestled with it. Up until now, we've decided not to create one this year. The vote of the committee was finally to create one. So this will do a couple of things. So like John said, this could potentially be a solution for agents who are trying to assist sellers with the sale of just a boat slip. So not a house, just a boat slip. We heard from agents down by the coast mostly. I don't think really much in our region, not that I can think of, but down at the coast, it seems to be a fairly common practice that people will own just a boat slip, just a place to put their boat, and they are bought and sold independent of property. And they were using the vacant land listing agreement because there really wasn't a great place to put those. And so this would now potentially take care of that, again, depending on the specific situation with the specific boat slip, deeded versus not, all that good stuff. This will also handle the situations where the seller wants to include the movie theater chairs and the pool table and the flat screen TVs, but lenders will not allow those items on the contract. Many agents have reached out to their favorite local closing attorney and had a form such as this drafted. So everybody was using them, just their own version of them. We felt like it was finally time to have one uniform form that everybody could use to streamline the process. The checkbox on here for is or is not contingent on the sale of the property. So if you're selling a house and you want to include the movie theater stuff and the projector and the pool table, obviously the seller probably doesn't want to sell that stuff to the buyer unless the sale goes through. So that would be, it is contingent on the sale of the property. So if the property contract falls through, this agreement would also then be null and void. In the not contingent situation, that would be such as just selling that coastal boat slip. Anybody else have anything on this?
I think it might be worth pointing out that we do have in here that the seller will bear the expense of executing any documents to facilitate the transfer. So if you're doing a boat slip that is separate from sale of real property, there will need to be an attorney involved. There will need to be, recording documents for that. The seller bears that cost unless the parties make some other arrangement. And down in the bold section, the property is being conveyed as is, and the seller is not making any warranties about this personal property again in that section. So this is another form that I've heard thus far great feedback on. People are very excited about this form.
I will add, do not attach this to the real property contract. This is not an addendum. I repeat, this is not an addendum. Okay, do not attach it. Lenders don't want to see this. They don't care. This, the whole reason this is here, and actually, upcoming cycle, I want to fix potentially, if the forms committee will let me, the personal property part of the real property contract anyway. Lenders don't like this stuff in there. Use this to get that personal property out of the contract. Do not attach it. All right. So if you remember, at the beginning of this presentation, I showed you how to navigate through the Q&As. If you go back to that and navigate, the top two Q&As, my Q&A about 8H was actually last week. This week on Monday, my partner wrote a Q&A about these new check boxes on the termination form. So let's talk about it a little bit, but also, feel free to look at his Q&A and make sure that you're getting the full context. So the first new checkbox, and this would only be as to the buyer because the seller's making a representation about governmental compliance, right? So the seller's not going to have a similar checkbox on their termination forms. However, this just gives the buyer the opportunity to terminate because that condition is not been satisfied. Again, this is exactly just like the other condition in the paragraph about real property at closing, which is another checkbox that's not on the screen, but it is in there. The bottom two are just a common situation. I get calls when I'm on the hotline. I'm on the hotline about 4 days a week usually, and it's pretty much something where a question I'm going to get 2 to 3 days a week, where either the buyer or the seller, usually the buyer, is holding the seller hostage by refusing to terminate, refusing to sign a termination, refusing to participate in the termination, to basically hold up the seller and maybe drag their feet so that the seller can't terminate and move on and relist the property. So in order to avoid that, this bottom two boxes are actually going to be options for the buyer and the seller. Now, these come with two major caveats. It's repeated twice and it can't be emphasized enough. The first checkbox at the bottom is the buyer gives notice of termination and alleges the seller's breached the contract. Now, maybe the seller has not breached the contract. We don't know, but if the buyer really wants to allege that, then they can. This hopefully will result in you guys not sending emails alleging those kinds of things to the other side. Please stop doing that. If you're doing that, it's not your job to advocate for the legal rights of your client. If you're getting into a contract breach situation, you need to back out of it as quickly as possible and recommend your client get legal counsel. However, to make sure that there are terminations, clear terminations for both the protection of the buyer and the seller, these two checkboxes have been added for that. However, you can see in that the first checkbox at the bottom, the buyer strongly advised to seek legal counsel, and you're going to want to remind them of that again before they do it. The last one is the buyer gives notice of termination after expiration of the due diligence period without providing a reason, and the buyer strongly advised to seek legal counsel. Again, this is so that the parties are not going back and forth with whether or not one party, if the buyer sends, say, form 390 is the termination form that requires both parties' signatures. If your client, doesn't want to send that, they want something to clearly, cut off the contract, you can use this now instead of sending 390 and just hoping the other side signs it and getting into some kind of bicker fest about, what happens if the other side does not sign. That's what these are to do. However, understand these new checkboxes throughout the termination forms don't give any new rights to the parties on when they can or cannot terminate. Not at all. And it's just to give you an option to be able to facilitate terminations when the parties just can't get on the same page about what the terms of termination might be, especially if the due diligence period is already passed.
Okay, so this is for 730, the referral agreement. So there's been new language added. Before it was on or before a date, but now we've just made it an end date. So you're referring, for example, let's say you refer an investor or someone buying lots, and there's maybe multiple purchases or listings in that with that client. So now you discuss upfront, what is the end date? Is it 2 months, 6 months, 9 months, a year, whatever the term of this referral agreement is. The first section is for a seller or a listing. The second section is for a buyer or someone purchasing. Same language, it's just one or the other. You might have both. Someone might be listing and selling. But if the prospect closes and sells more than one property prior to the end date, referring firm shall be paid on each transaction unless otherwise provided in here. So it puts an end date on how long does this referral agreement last.
And if I could add on, those lines at the bottom, if you, instead of making it a blanket, all transactions within that time period, if you want it to be restricted to just one address or one purchase, then we can use those lines at the bottom under other to specify that.
So this concludes our presentation. I want to thank everybody for listening so far, but don't leave. If anybody has any suggestions that they would like to send to the Forms Committee, you can do so by emailing forms@ncrealtors.org. And we're going to turn it over to the Q&A with Tiffany. Thank you so much.
Thank you so much to all of our panelists. You guys did a fabulous job. And as you can imagine, we've gotten a number of questions in the chat, and I know we've answered a good number of them, but I've still got at least 22 open questions, and some of them were repetitive. So if you don't hear your specific question, no, we're trying to get to as much as we can. One of the bigger pieces was the definition of material and how you decide on what the buyer and the seller would deem material. Is there a list that we can refer to or any guidance that we can provide to our agents that will help them talk to their buyers and sellers about what is material for 8H?
You know, there's not any specific guidance or examples, you know, other than the ones I gave today. What I would say about this is the same thing as any sort of legal dispute between the parties with respect to the contract. And this is something that I really want to try and move away from as much as possible. You know, I am fully aware that, you know, you guys are in a very difficult position when it comes to these transactions, because on the one hand, you're using these forms, you're negotiating contracts, you are in sort of a quasi-legal capacity that you certainly are very good at and entitled to be in as brokers. However, recognizing that moment in time where it's no longer about negotiating contract terms, but really about whether one side is alleging that the other side is in breach or not, is something that I never encourage agents to get involved with. You really need to step out of them as quick as possible. So what I would say is this: if something comes up in 8H and you really don't feel like it's material, or maybe you do feel like it's material, then, you know, you can say, listen, I'm not a lawyer. To me, based on the training I've had, this seems like it is or is not material. You know, you can give your opinion as a layman, and then say, but listen, if you really want to fight about it, you need to go hire a lawyer to go fight about it, because that's not really my role. And so that's what I would encourage agents to do, and really to try and get out of that instead of having a specific list. This is something where, again, hopefully it brings some balance and parity to the buyer and seller with respect to these issues as they come up. And, you know, if they really want to get down and dirty about it, then they need to go waste some money on lawyers, because, you know, that's what you may or may not be doing depending on the circumstance.
Thank you. Our next question is relative to home inspections, and home inspectors often will refer to a code that is not in compliance, even if the house is, say, 20 years old and the code is 5 years old. Is that a material issue if the home inspector notes something? And the concern there was every home inspector is going to note code violations based on code today versus when the house was built. And if no changes had been made since the house was built, how would you navigate that?
Yeah, again, I think it's going to depend, you know, whether it's is it going to be material or not? You know, is it something that's actually significant or not? I mean, we all see inspection reports. Some parts of those inspection reports, those code compliance issues, those are not going to be material. They're small, again, issues. But if there's a big one, yeah, I mean, it could potentially come into play. That said, I think most of the time, most situations, if a property is in compliance at the time that it is, you know, at the time it's built, you know, say the addition is done, if it's built to code at the time, then it should be in compliance. And maybe that's something where we're going to have to look at the language and make sure that that particular concern is addressed. But I don't think it was the intent of the paragraph, and I'll let panelists weigh in too. I don't think it was the intent of the paragraph to capture code violations that arise later because the code changes, not because there's been some kind of failure to adhere to the current code at the time the particular change is made.
Thank you. Did anyone else want to chime in, or can we move forward? Okay, we've got a lot of questions. The next one is, what if the previous owner did something and you had no idea there was an update or permitted, or you're an heir and you really don't know what happened with the property?
There's actually discussion about this. I don't know, Melanie, you could refresh my memory. I feel like this discussion was mostly in joint forms, but there was extensive discussion about this. And really what it was felt is that the seller is in the best position to know. Is it always going to be perfect with respect to changes made by previous owners? No, but the seller's in the best position to know. They either should know or, you know, or have the best ability to know. There was also an argument by some members of the bar. I don't think this really came from any realtor members, but there's no real innocent seller, because there are affirmations you make to the tax office even while you're there that your property is being taxed appropriately. You have legal obligations to make sure that you are doing what you need to do while you're the current owner, with respect to what a previous owner has done or not. And that argument got more legs with some people rather than others. But in any event, it's going to go to the current seller. And if there was something from the previous seller, then yeah, those situations could potentially be caught in something like this. But on an estate issue, I think that's something where number one, the RPOS is not going to apply anyway, and we hopefully this next form cycle we're actually going to have like a cheat sheet for estate transactions. And if we can get that done, that would be great. That's one of my goals for next cycle. But one of the recommendations in that cheat sheet is if you're selling estate property, you need to get a lawyer involved at the beginning rather than the end anyway. There's too many issues to navigate to not have a lawyer on the front end. So that a lawyer will help with this particular affirmation as part of that.
There is a question regarding if a buyer has an unpermitted deck and checks no representation on disclosure form regarding violations, and agent discloses deck unpermitted in MLS. Is there anything else for the agent to satisfy compliance under the new governmental section? And that probably should have been if a seller.
Yeah, no, I think that's exactly right. Mm-hmm. Get it in the MLS and just make sure that if you're putting it in agent only remarks, if you get an unrepresented buyer, that you somehow get them that disclosure also.
Okay. And so it says just give reason and not legal counsel, but by selecting the box, we are already determining if they have a legal path. And I believe that's in the termination forms. So if they're seeking legal guidance and they check that box, but they haven't gotten the answer from legal, is that the proper method? I believe is the question there.
Yeah, I mean, you can't force the horse to drink the water. I mean, all you can do is recommend what's best for your client, which I think in that situation is to get legal counsel. If they don't want to do that, then they don't need to do that. That was my advice before these checkboxes came into existence. It's now, and I don't think you're necessarily choosing a path, just by checking a box. All you're really doing is providing a better foundation for the termination.
And if I could just jump in there, this was a change that it took me a while to get comfortable with. And John kept reiterating, this is giving agents an option that we don't currently, or prior to July 1st, that we didn't have. So it's really a service to us to be able to provide this in a form for clients. We are not at all weighing in on whether or not it is the right thing to do or whether or not it's valid. It's simply giving us a tool that we didn't have before.
Thank you, Melanie. The next question is, does a seller need to disclose if a home is in a water quality buffer zone? I see Melanie shaking her head.
I would say yes. I mean, especially if the water quality buffer zone could limit what could be built with that property. You know, some have buffers and things, and you can't put a shed or a deck or a pool. That could change a buyer's desire to purchase the property or change the price that they may pay for it, therefore be material to their decision-making process. So yes.
Thank you, Amy. The next question says, does the issue with governmental compliance have a time limit, i.e. like 20 years?
I mean, there's no time limit stated in the paragraph itself. I will say that, paragraph 4H is still in the contract. And that says if you close, you're taking the property as is. It's a difficult bar for any buyer to get over if they accept the property at closing. And then they want to allege that something's wrong with the property afterward. The same rights that you had before are still in there.
Okay, thank you. So I have let me rephrase this. The form said that if the seller was not a FERPTA, they would need to disclose that on the compliance form. The vast majority of sellers would not be formed, but they need to complete the compliance form, was the question.
Well, I think the intent of the check boxes in the exclusive listing agreement was, and this was at the urging of a realtor member, was just to make sure you're having the discussion with your client. And if they check that they're not, then, yeah, they're going to fill out the affidavit. But, well, even if they don't fill out the affidavit, there's going to be consequences one way or the other. So I don't think that changes at all. It's really just to make sure that the listing agent is having that discussion with their client on the front end.
Okay, and then we have a client that asked, or an agent that asked, what about safety and insurance implications if someone is injured, like deck built without a permit? And I think there's liability there.
Well, I mean, it's kind of hard for me to answer that without further context. When does the injury occur? Why does the injury occur? I'm not sure I understand that question.
A little vague. Okay, so then the next question is, what is the duty of a listing agent to ask more probing questions to a seller if they do check no representation on a question on the residential property disclosure? And what would be the best practice in this scenario?
My understanding from the commission, now, mind you, I'm not an attorney for the commission. So, I'm just general counsel for NC Realtors, but, we obviously have a lot of contact and interaction with them. So I can answer this as far as I understand the commission's position. The commission's position is not, there's what your client puts on residential property disclosure. You're supposed to go over that form with them and help them fill them out, which, by the way, there's a huge revision coming out with that. And it's in a comment period right now. If you haven't commented yet, you might consider looking at that and providing some comments. I know I will be. In any event, what the commission expects is that if there's red flags of some kind on the property, then you need to do a further investigation as the listing agent. That's your job. If there's no red flags, the commission doesn't think that you're some kind of psychic who can know everything about the property. That has not been my experience with them. I've handled dozens of cases in front of the commission for brokers on this issue, and that's just not how they approach it. They don't expect you to be infallible, but they do expect that if something should pique your interest to do further inspection about whether this is something that needs to be disclosed or not, they're going to expect you to do that.
Thank you. How is the commission collected on a 320T personal property form is a question that we have asked.
Well, there's no commission specified in that form. So, if you're helping to do that, if you have some sort of agreement to list personal property, like, well, here's a situation that comes up from time to time. You're just going to sell a trailer and that's it. Just one mobile home. Then what you would do is, you would need some kind of listing agreement to go with that. It's not real property, so, you know, our real property forms wouldn't do that. I don't think there's any will of the forms committee right now to start creating all sorts of forms for personal property. The personal property form is really to help with real property transactions. And so you're listing whatever your agency agreement is for the real property transaction. That's really what you're looking at. That personal property form is really just meant to facilitate those transactions.
The next question I have is, can you give a couple of examples of how a buyer could get their due diligence money back regarding 8G and H on the 2T today?
Well, I hate to be repetitive, but you know, that's something where if when the situation comes up, if your client feels like there's been a violation of one of those two and the seller doesn't agree, let's say the buyer thinks that something's not in compliance with one of those paragraphs, seller disagrees, then they just need to go get lawyers and fight about it. That's all there is to it. That's their remedy. That's their recourse. Nobody's going to show up at anybody's house with baseball bats to fix that situation. That's not what baseball bats are for. That's what courts are for. So yeah, I think we've already given a lot of examples on that. And I think when those things come up, again, back out as soon as possible and be like, listen, if you want to fight about it, then you need to go get a lawyer and fight about it.
Okay, I have another question that says, if the additional check boxes on the termination form used for both buyer and seller to terminate the contract when the other party doesn't sign. So I think what they're asking is, have they effectively terminated the contract if they send one of those unilateral termination forms over?
In most circumstances, yeah. Now, let's say, this is probably an important thing to bring up. Let's say the seller does it. Now, the buyer has some pretty good remedies. If the buyer's in compliance with the contract, seller wants to terminate, you know, the buyer can turn around and sue for specific performance and have a pretty good success rate with forcing the seller to sell. And furthermore, you know, exposing the seller to attorney's fees if they don't complete it. You know, the risk is for something similar for the buyer is not quite there. For the seller, there's a pretty big risk there. What you guys already know about, I think you handle those situations on the whole very well. So that's not really, this is more something, the reason it's there for the seller is to give you the tool for the client if they need it, so that you can probably help them terminate and then probably get out of the listing at that point with someone who's difficult like that. But on the buy side, it's really, to avoid confusion about whether the transaction is terminated or not, so the buyer can move on if they want to another property.
Okay. I see a question regarding the working with real estate agents form, and I think I've seen it pop up a couple of times. That is a North Carolina Real Estate Commission form, not an NC Realtors form, so that would be something we'd need to go there for. Were we able to view comment on the changes to the property disclosure? That's at the NC Rec site, and I believe we could probably put that link in the chat. If you have an unrepresented buyer and you provide them with the residential property disclosure and the mineral oil and gas rights, do they also need to sign the document? If they don't sign the document and you've checked it, what happens then is a question.
I mean, the duty of the seller is to deliver it. If it gets delivered, and especially if you can show it's delivered, then it doesn't matter if the buyer signs it or not. The sellers performed their obligation.
Okay, I have someone asking about the notification of septic on another lot and no checkbox for things that are not deeded or in an easement.
If I understand the question correctly, the changes that were made say that it's an off-site septic, which means that it's off-site, means it's not on the property. So I think probably the form already addresses that question if I'm understanding it correctly.
Great. So I have a question that says, if this form is used and contract is terminated, are agents required to share as a material fact or share a copy of this with buyer's agent?
Share a copy of what?
Probably share a copy of the material fact or the reason why it was terminated. mean, once you have a material fact in hand, it's your obligation to disclose it, correct?
I thought the
So-
question might be asking if they share the actual termination form, was how I read the question.
Hmm.
Which to that I would say, no, I don't think you would ever disclose the specific form used for another transaction for a new. Now, if it was terminated and the termination was a material fact, then yes, that material fact needs to be disclosed, but not done by showing that form, just by communication from the listing agent.
Thank you.
Tiffany, can I go back to the subject question previously?
Sure.
So I think what they were asking is, so we're talking about specifics of where it is legally on another site, but there are instances where, like, especially like with a family land in a rural location, the property got divided up, a well or a septic may be on another lot and the lines just didn't get divided. That definitely needs to be disclosed, and the attorney needs to be advised. So if there's something that needs to be addressed as far as an easement or some kind of legal documentation, that it, they have access to that. So it would be something where it is already legally allowed, but there are lots of instances where things were divided up and driveways, septics, wells, et cetera, garages are on other pieces of property. So I think that would be under that section as well.
Hey, does anyone else want to clarify anything that they have seen? I do have a question regarding retainer fees, which I don't believe we discussed here. It says, is it due at time of agency agreement being executed, or can you request it from the buyer up to the time of closing?
So I just did a quick peek at the buyer agency, and I don't think a time frame is laid out. Anybody else know of one in the buyer agency that I can't think of? So perhaps something to submit to us and take a look at in front of the committee if we think that a time frame needs to be added to that, because I can't find one.
Well, I mean, if I'm understanding the question correctly, are they talking about a non-refundable retainer in, say, the buyer agency agreement? Is that what they're talking about?
Yes.
I mean, what the commission requires in their rules is that the compensation be determined at the time the agency agreement is signed. So can you request a retainer later? Yeah, sure. I think you request it, your client can say no and decline to sign it, in which case, whatever compensation you have in the agency agreement, that's what you're entitled to. If there's no retainer in there, then you're not entitled to one. So I'd say definitely get those on the front end, because once your rights are to compensation are determined in the agency agreement, that's what's going to be binding until the agency ends.
Thank you. We have another question regarding 8H, and I think I know the answer, but I'm going to let you guys speak to this. It says, given that there seems to be additional clarification on the 8H topic, would we continue to use the old ERS and OTP forms until the clarification is completed? Not the case.
No, you got 60 days grace period at the end. That means August 30th is your last day to use the old forms. August 31st, under the forms policy, you use the new forms.
And it seems like there are a number of clarifications, but if a house was built in 1970 and there have been no permits and they've replaced the dishwasher, they've replaced some lights, how do you disclose that?
Well, I think you would just disclose them, but neither one of those things sounds material to me.
Okay.
So
Thank
even if they're not disclosed, I don't see it. I think here's the way I think about it, because in the past, before I took over this role, I did litigation for a long time. And so I always examine things in my head of how do I think this is going to play out in court? And I really try to be fair about it. If you are someone who wants to take those two items, for example, to court and say that those are material things, that because they weren't disclosed, that now you are entitled to terminate under the condition that property is not governmental compliance. You think a judge is really going to buy that? I really don't think so. I think you got a tough case there, and you are certainly free to argue it. No doubt. You want to pay the money, to a lawyer to go argue about that. That is, you're right. You have First Amendment right to the access to courts. But at the same time, you know, if it gets there, do I really think, in just my opinion, whether there's a good chance of success? No, not really.
Okay. One other question is relative to if a listing agent makes the disclosure, can the buyer still exercise the right to terminate with a refund of their due diligence funds and their earnest money deposit funds for 8H? So listing agent makes the disclosure, the seller does not.
Yeah, no. If the listing agent makes a disclosure, they're the agent of the seller. I mean, whatever disclosures a listing agent makes, that's on behalf of the client, you know? So yeah, no, that works.
And what is the best way for a listing agent to make that disclosure so that everyone has acknowledged it?
I mean, I always encourage agents, if at all possible, get all disclosures on the residential property disclosure statement. If you got a difficult client who won't do that, okay, you know, I understand that. Then maybe you're going to have to just make whatever material fact disclosures you need to make in the MLS without that being on the RPODs. But the RPODs and the MOG are generally the best ways to make those disclosures. So we always strongly encourage agents to get it on there if at all possible.
And then another best practice, if the seller won't agree to put it on the RPODs, could be for the listing agent to send an email to any interested buyer agent and get a response email, like confirming that the buyer agent has shared it with their client.
That's great. And if
I wanted to add one more thing really quickly, as far as disclosing an MLS. We were all kind of surprised this year when we were having a conversation about disclosing as listing agents material facts in MLS. And a representative from the Real Estate Commission pointed out to us that we were very good about putting it in agent remarks, but we were very bad about putting it in public remarks. And the comment was that we hide things in agent remarks. And I think we were all really shocked by that. That was never our intention. But if you think about it, if there is something that is very specific, in my case, I had a property with an easement. I immediately went and put it in both agent remarks and public remarks because it was a seller that was exempt from property disclosure. So think about things that you might want to have in both public and agent remarks if you're disclosing something the seller has not.
Thank you for those last parting comments, Jennifer, and I appreciate all of the panelists for being here. I know we all do. It's been very informative and very helpful. We will have all of the Q&A available as well as a recording of this within the next week or so at canopyrealtor.com. So please look for that. If you have any further questions, you can reach out. Again, thank you all for your time. We appreciate it, and we appreciate your commitment to help in creating the forms for our association members. Thank you.